Welcome to this presentation relating to Chapter 6 of our textbook. This chapter covers criminal law and business. This is our only chapter that we spend talking about criminal law, and the reason that we don't spend more time is that it's not very relevant for most of the business activities that you'll be engaging in, or at least I certainly hope it won't be too relevant. But certainly criminal law does play some role in the business community. It can affect your business in lots of different ways. For one thing, it gives you guidance as to what is prohibited, what you ought not do. It also lets you know what your protections are or what your avenues of redress might be if somebody commits a crime against you. If you know that the behavior is criminal, then you are going to want to contact the appropriate law enforcement personnel and proceed along those lines. And you may also have some civil remedies. So we're going to look at this fairly lightly. We're not going to do a very deep dive. If you actually do encounter a situation in your life in which you think that there may be some criminal law implications, I definitely encourage you to seek the advice of an attorney who specializes in that area. Again, this is just really a big toe in the water type introduction to this topic, so I don't want to lead you with the impression that we're going to do more than just kind of touch on those subjects. Let's get started. Okay, so we're going to start talking about substantive criminal law first. Let me just do a little bit of annotation here. If you imagine the world of law, all the laws that exist, whether they be statutes, constitutions, regulations, or judicial opinions, if you think about all of that law being this red circle here, and I'm going to divide the red circle into two parts, and I'm going to put substantive law over here. I'm not going to write the whole word. And then I'm going to put procedural law over here. I'm just going to put pro, but that stands for procedural law. That's a pretty neat way of dividing up the law. If something is substantive, for the most part, it's not going to be procedural. And if it's procedural, it's for the most part not going to be substantive. I'm not going to lie, there are some statutes that have substantive and procedural parts, but that's usually a pretty clean break between two categories of law. You may recall when we were in an earlier chapter, we talked about a couple of other ways of dividing up the law. For example, we talked about dividing up the law into civil and criminal law. And then we also talked about dividing up the law into public and private. So you can see that there's lots of different ways of dividing up the law. Imagine for a second that we were to bring all the people from our class in a room together. We could divide up the class into men and women. We could divide them up into people under the age of 25 and over the age of 25. We could divide up the room into people with blue eyes and people with brown eyes. We could divide it up into people who are left-handed and people who are right-handed. There'd be lots of different ways to divide up the room depending upon what we wanted to accomplish with the division. And so I guess you could divide up the law infinitely, but these three ways that we have divided up the law are useful from a practical standpoint. Let's talk for a second about what substantive law is. Many times legal professionals think of substantive law as answering the question, what? What does the law say I need to do? What are the details? What's the substance of the law? What does the law say that I can't do? What does the law say I'm entitled to have as a benefit or detriment? Let me give you an example of substantive law. A substantive law example would be a law that explained the taxes I needed to pay. If I earned this amount of money, I would be paying this amount of tax. Another example of substantive law would be a law that provided the reasons that I would be eligible to get a divorce. What would be the grounds for my divorce? That would be a substantive law. Another example of substantive law would be the law that describes when I am able to recover under a breach of contract claim. Finally, another example of substantive law would be a law that described the elements or the requirements that have to be satisfied before I can be found guilty of, say, arson. All of those are going to the substance of the law, the what of the law. And that's what we're going to cover first in this chapter. I'll be honest with you, in this course, not just this chapter, but really all the chapters, we heavily emphasize substantive law over procedural law. We do that not because substantive law is more important than procedural law, but we do that because procedural law is really something that the attorneys and paralegals, the legal professionals, are going to focus on. That's not really something that the layperson who's represented by an attorney needs to be expert on. Your legal representatives will know how to do those aspects of the law, and they'll tell you what you need to know in order to proceed in that particular claim. But knowing the procedure doesn't really help you as a business person to know what to do next in most cases. So we're not going to spend a lot of time on that. If you find procedural law interesting, though, I would encourage you to consider taking some LGLA courses. Those are our paralegal courses we have in a program. I, as well as many other faculty here, teach those courses, and I'll be glad to give you more information about those courses. We have 2 courses in our program that are exclusively about procedural law, and virtually all of our substantive law courses do have significant portions of which we talk about procedural issues. So we've decided that substantive law is about the what of the law. Procedural law answers the question, how? How am I going to protect those rights? How am I going to enforce those rights? How is the government going to enforce its rights against me? Let me give you some examples. A procedural law might be the law that tells me what is the name of the document I file in court. How many days do I have to file that document? What particular facts have to be in that document? How do I get that document to the other side? How long does the other side have to respond to that document? Who needs to sign these documents? Do they need to be notarized? What court do I need to file this in? Those types of questions are procedural questions. They don't talk about the substance. They don't talk about whether I'm going to win my claim or not. They just tell me what the paperwork and the particular process is that's going to give me a chance at winning if my facts are the right facts. For the most part, procedural law is not does not vary based upon the substance of the law. So there are some differences there. But let's say I'm filing a breach of contract claim. I'm going to be following the same procedural rules than if I were alleging a car accident case or employment discrimination. In fact, most civil cases are going to follow the same procedures. We call them, if it's filed in a Texas state court, we call them Texas Rules of Civil Procedure. If we're filed in federal court, we'd call it Federal Rules of Civil Procedure. We do make a distinction in procedural rules between the criminal system and the civil system. The reason that we do that is severalfold, but the most important is that there are important constitutional protections available to criminal defendants that aren't available to civil defendants. And those protections affect how we're going to proceed, what that process, what those procedures are going to look like. So we have separate set of rules when it's a criminal case. If the criminal case is filed in Texas state courts, we call it the Texas Rules of Criminal Procedure. If it's filed in federal court, it'd be the Federal Rules of Criminal Procedure. And that's a very common way to break up the law, whether we're in Texas or probably virtually any other state. So the how of it doesn't vary that much. Of course, the substance is going to be different for each claim that we might make. So let's go to our next slide here. Okay, let me make that go away. Okay, so we have to talk about elements. If we were in a chemistry classroom right now, I would turn behind me and point to the periodic table. And we'd see lots of very colorful boxes. One would be for hydrogen, one would be for oxygen, one for argon, one for helium. All of the elements would be on the board. And I could say to the class, well, what's the recipe? What elements do I need to make water? And pretty much everyone would raise their hand and say, well, you would need hydrogen and you need oxygen. And of course, if I just had oxygen, I couldn't make water. If I just had hydrogen, I couldn't make water. I need to have both. That's the quote-unquote recipe for water. Those are the elements for water. They're the required stuff I need in order to make water. Well, we have a very similar element in the law, and we actually use the same word for it. When we say something has elements, in this case we're saying a crime, but it could be, a civil cause of action. We're saying you have to have these things. You have to have these elements. You have to have these elements in order to have this item right here. Okay? So if you're missing one of the elements, you don't have a crime. You might have more elements than you need, and that still would mean you'd have a crime, just like the water that you have might be contaminated with some other things that aren't hydrogen or oxygen, but you'd still have water. Similarly, you can have more stuff, but you have to have everything that's required. Well, generally speaking, crimes need two categories of elements. They need an actus reus and a mens rea. Let's look here for, oops, here we go. Hit a wrong button there, I apologize. You can see after actus reus, you have the word reus, and you can see it ends US. And then we have mens rea, and that ends with an A. The US ending is a masculine ending. In Latin, adjectives typically come after the nouns, kind of like Spanish or French, and they will match the noun in terms of endings generally. So if the noun is masculine, like actus is, then the pronoun, in this case reus, would also be masculine. Mens, though, is a feminine noun, and so it's going to have the A ending, reus. Now I realize mens doesn't have an A. It doesn't follow that general pattern. It's an irregular noun, but you can see because it's feminine, we're going to have an A here. So even though these two words don't look the same, they actually mean the same. It's just because the fact that actus is masculine and mens is feminine. And just like in Spanish or French, the fact that this is masculine, this is feminine doesn't have any, biological meaning. It's just the way that the language is organized. Most of the gender of words don't refer to gender in a biological sense. Okay, so we have actus reus, which literally means guilty act. So reus means guilty or bad or wrong or evil. And actus means act. And we can actually see the word act in this word. Okay, now let's go to mens rea. Again, we can see the rea means the same thing as bad, but this means guilty mind or guilty thinking. And you can actually see that here too, because this is the beginning of our word mental, right? So just like we can see act in actus, we can see mental in mens, showing that even English has some remnants of the Latin in the way that we say certain words. So we have an evil act and an evil thought. We need to have both in order to have a crime in the majority of cases. Now, we may need to have multiple guilty acts or multiple guilty thoughts. A lot of crimes have more than just two elements, but usually we're going to need to have both. Let me give you an example of how we look at this issue. Imagine for a second that I have an next door neighbor. We'll call him Bob. Bob has been playing his stereo very loud late into the night, every night for the last several nights. Honestly, I haven't gotten any sleep. I have to work during the day. I'm just bone tired and so angry at him. And in fact, as I lay in bed at 3 in the morning hearing his loud music, I'm just gripped with rage at him. And I start fantasizing about all the ways I could torture him and his family, and I engage in all these extravagant fantasies of me, throwing gasoline on him and striking a match and burning him to death, or cutting the brake fluid line in his car and letting him crash and die. And I'm really enjoying all these elaborate and fairly sick and twisted scenarios. But you know what? I don't do any of them. I just think about them. I don't even tell anyone about them. have I committed a crime? No, I haven't. I have engaged in mens rea, in a guilty thought process, but I haven't done any acts.